All right, everyone, exam time is almost here. So let's jump right in and absolutely nail one of the most important topics in business laws, contingent and quasi contracts. We're going to make this super clear, super simple, so you can walk into that exam feeling totally prepared.
So think about it for a second. Not every contract is a simple, you do this, I'll do that, right? A lot of deals in business and in life really hinge on a big what if. They depend on some future event that might happen or it might not. So how does the law even deal with a promise that's built on a maybe?
Okay, so this brings us to our first big idea, contingent contracts. Honestly, the easiest way to think about these are as the what if deals. Their whole reason for being, their very existence, is tied to a condition, some future event that decides if the contract actually kicks in or not.
And here it is, the official definition, straight from Section 31 of the Indian Contract Act. Now I know, it sounds a little heavy, a little technical, but don't let the legal jargon throw you off. The only words you really need to focus on are if some event and collateral. We're about to break down exactly what those mean. So let's make that real. The best absolute classic example is an insurance contract. Think about it. The insurance company's promise to pay you isn't guaranteed. It's contingent. They'll pay you if, and only if, your house burns down. That fire is the uncertain future event. No fire means no payment. Simple as that. Okay, for your exam, you have got to remember these 4 key points. First, the performance of the contract depends on a future event. Second, that event has to be collateral, which is just a fancy way of saying it's outside the main deal. Third, it can't just be up to the whim of the person making the promise. I'll pay you if I feel like it. Yeah, that's not a contract. And finally, number 4, the event has to be genuinely uncertain.
All right, so we know what these things are, but the big question is, when can you actually enforce them? When can you make someone follow through on an if-then deal? Well, the law gives us a really clear set of rules. So let's get into the rules of the game. Rule number 1, coming from Section 32, is pretty straightforward. If a contract depends on something happening, you can only enforce it once that thing actually happens. So if A agrees to pay B when B marries C, you can't enforce it until after the wedding bells ring. And if C dies before the wedding, well, the event just became impossible, so the contract is now void. It's off the table. Now, let's flip the script. What if the deal is based on something not happening? Section 33 tells us you can enforce it only when that event becomes impossible. Let's say I agree to pay you if a certain ship doesn't come back to port. The second that ship sinks, its return is now impossible, and that's the moment my promise to pay you becomes enforceable. Okay, what happens when there's a deadline? Section 35 covers this. If A promises to pay B, if a ship comes back within 1 year, the contract is good if the ship makes it in time. But if that 1-year mark passes and the ship is a no-show, the contract is void. The clock ran out. And finally, we have the common sense rule from Section 36. If you make a deal based on something that's just plain impossible, like paying someone to discover treasure using magic, it's void right from the start. The law isn't going to waste its time on things that can't possibly happen. All right, everyone, lean in for this one. This is a classic exam trap, and so many students get it wrong. People often confuse contingent contracts with wagering agreements, which is basically just betting. They both deal with an uncertain event, sure, but in the eyes of the law, they are worlds apart. You have to know the difference. Just look at this table. It makes it so clear. The single biggest difference? Validity. Contingent contracts are totally valid. Wagering contracts are void. But why? It all comes down to interest. In an insurance contract, you have a real, genuine interest in your house not burning down. With a wager on a cricket match, you have no interest in the game itself other than the money you'll win or lose. That distinction is everything. Okay, let's take a deep breath and switch gears completely. We're about to dive into something really fascinating, a situation where the law actually creates an obligation even when there was no agreement. No offer, no acceptance, nothing. Welcome to the world of quasi-contracts, which I like to call the uncontracts. This quote right here, this is the heart and soul of quasi-contracts. The entire idea is built on fairness, on justice. The law basically steps in to prevent something called unjust enrichment, which is a fancy way of saying it's not fair for one person to benefit from someone else's loss or mistake.
So let me be absolutely clear, because this is crucial.
A quasi-contract is not a real contract. It's a legal tool, a remedy. It's like the court is acting as a referee, blowing the whistle and saying, hey, you two never made a deal, but this situation is unfair, so we're going to create a contract-like duty to make it right.
Now, the law doesn't just vaguely say, be fair. That would be a mess. Instead, the Indian Contract Act gives us 5 very specific situations where these quasi-contract duties are created by law. Let's walk through these 5 scenarios. This is your framework for the exam. So here they are, the 5 big ones from sections 68 through 72. We're talking about supplying essentials to someone who can't contract for themselves, paying someone else's debt to protect yourself, getting a benefit you didn't pay for, finding lost property, and paying money by mistake. Let's quickly hit each one. First up, Section 68. Say you provide necessaries, like education or food, to a minor. The law says you're entitled to get that money back. But, and this is a big but, you can only get reimbursed from the minor's property. You can't go after them personally. Next, Section 69. Imagine you're a tenant and your landlord just stops paying the property taxes. Now, to keep the government from seizing the property and kicking you out, you pay the taxes yourself. Because you had a direct interest in doing that, the law says the landlord is legally obligated to pay you back.
Oh, this is such a great real-world example for Section 70. A Swiggy order for your neighbor gets delivered to your door by mistake. You just go ahead and eat it. Well, that food wasn't a gift, right? It was a non-gratuitous act. Since you enjoyed the benefit, you are legally on the hook to pay for it. Sorry.
What happens if you find something that isn't yours? Section 71 says if you find lost goods, you have the same responsibility as a bailee. That's just a legal term for a caretaker. It means you have a duty to take good care of the item and make a reasonable effort to find the actual owner.
And finally, Section 72. This is the oops rule. If you pay someone money by mistake, like accidentally paying the same bill twice, they have to give it back. The person who received the extra money has a legal obligation to repay you. It's just simple fairness.
Okay, let's do a super fast recap. Here's what you need to burn into your brain. Contingent contracts. They're real, they're valid, and they're all about an if-then scenario. Quasi-contracts, they are not agreements at all. They are legal duties created by a court to make sure things are fair. Get that difference straight, and you are in great shape. So let's end with a little brain teaser. You find a nice watch in a restaurant. You do the right thing and give it to the manager to keep safe for the owner. Later, you go back, but the manager says, nope, it's mine now and won't give it back to you. Can they legally do that? Based on what we just learned about the responsibilities of a finder of goods, you know the answer. Now go ace that exam.